This conference will now be recorded.
As Giles was saying, if you want to ask any questions as we go through, you can unmute yourself and you can ask it by audio if you want to do so. Again, that's always a good way of doing it in terms of interaction, etc. Or if you're feeling a little bit shy, then you can just type into the chat box and you can ask questions that way, or comments again, because I'm sure there'll be lots of ideas and suggestions by the people that are attending, which other people may want to take on board when we're discussing, in particular, regarding rent arrears. Okay, so minimizing rent arrears and the debt respite. That's a word. For some reason, that's a word I can't seem to say properly. But respite scheme, which I'm sure a lot of you have heard about in relation to not being able to pursue certain debts for a period of time when someone has been, or when you have been notified by a particular body. So that's coming into effect on the 4th of May this year. So again, I don't expect it to be widely used by tenants because in the end, having read it into a lot more detail, I don't actually think it gives tenants as a general rule too much protection. It will give certain people at certain stages of their life protection for a period of time. But as a general rule, I don't think it's going to allow what I'm going to call bad tenants off their liability or from properties being repossessed if they are in rent arrears. So it doesn't sound as bad as when you pretty first heard it in terms of headlines in national media, etc. So let's look at minimising arrears. And again, for those that were just here before we started, it's one of those situations whereby it's one of those scenarios where the horse is bolted. So actually, there's a lot of processes and procedures that you could put into place before you let a tenant into the property, which could minimise or reduce the risk that you face as a landlord, which I'm sure most of you are aware of, but it's always good just to revisit what you could do as a landlord, because I fully accept landlords in the main are a lot less secure in what they need to be doing in relation to an application. So before the tenancy starts, again, so what protections can you have in place as a landlord? And so, for example, we're talking about rent guarantees, those types of scenarios, which lots of landlords were less likely to take out than maybe letting agents who I work with more commonly. So again, it'd be interesting to hear if landlords have considered or did prior to COVID take out rent guarantees, because in the end, actually paying a rent guarantee premium each month in the long term may be much more economically beneficial than having a tenant obviously in rent arrears. So it'd be interesting to hear out of the 18 odd attendees on this particular course, how many of you actually do have rent guarantees in place for current tenants or would now consider taking on rent guarantees, because rent guarantees aren't just limited to letting agents, landlords can get them as well. I fully accept the cost can be prohibitive to a certain extent. It reduces your profit margin or whatever it's going to be. But ultimately, it could be a calculation that you decide that is beneficial to you as a landlord when you're dealing with applicants. So rent guarantees, as I said, there are lots of providers out there. Obviously, economies of scale probably works against you as a landlord. So lots of my letting agent clients will have 200-300 properties, and they get a better rate for their client landlords than individual landlords who approach a company as with a smaller portfolio. Obviously, I don't know if it's actually, Giles, I don't know if it's something which MPO has access to in relation to insurance in terms of rent guarantees, but that would be something I would certainly say that landlords would be well advised to be certainly looking at now. And there is certainly a big market out there for providers of such insurance policies, but they can be, as you know, quite expensive, and the premiums have probably doubled in the last 6 to 12 months. So it's just really look at all those different types of issues. You can actually get them for current tenants. So some insurance policies will obviously look at it and say, okay, if your current tenant isn't in rent arrears, if they reference correctly through our process, or if you use a professional referencing company, we would potentially offer you rent guarantee. So if you were concerned about a current tenant or the current situation, you needed it to pay your mortgage or whatever it's going to be, then you could consider, even if you've got current tenants in situ, getting them re-referenced if you hadn't had them referenced previously, and getting rent guarantees. I don't know if you unmuted yourself there, Giles, to say anything, but if you want to.
No, I mean, it's something we are looking at, rent guarantee, with our insurance partner, PIB Insurance of Derby. But as you've alluded to, very expensive, loads of conditions. So we're just going through that process right now. So hopefully we'll have some news for members in due course.
Yeah, no, thanks, Giles. It'd just be interesting to see. I mean, you don't have to say whether you actually, if anyone wants just to say, yes, I do, I do have rent guarantees as a landlord, and maybe a comment, maybe about how you find it, whether it's beneficial for you, any negatives that you find. But I fully accept that insurance companies aren't there to pay out nilly-willy, so there are lots of terms and conditions that are attached. But I do work with quite a number of letting agent clients, and in the main, I would say that the rent insurance companies are acting professionally and honestly, and lots of my clients have been able to claim against the insurance policies without any real quibble. So they're getting some like 12 to 15 months worth of cover. So that's what they guarantee you as a maximum, which is probably about the time scale it would take for you to serve possession or serve notice to a tenant and get possession through court. So rent guarantees are certainly there for you. I think some of my clients are paying in the region of £20 to £25 a month for a policy. So just to give you an idea, I fully accept that from a letting agent perspective, you may be able to find something a little bit cheaper depending on the cover, or it may be a bit more expensive purely from the fact that obviously you're only bringing a small portfolio over to that particular provider. So again, it's something which I think I would be interested in having more discussions with Giles about if I was a landlord, if EMPO were able to secure a deal which allowed them to which would allow them to maybe provide a discounted service to their clients or members. I think Richard just asked about Charnwood Borough Council in terms of a mediation service. We don't talk about mediation services today, but there are a number of mediation services available. Obviously, the courts themselves want you to go down the mediation route. For those that have been down a Section 8 notice in particular, there is that obligation to see if mediation would work in relation to reducing rent arrears. So a number of councils will potentially offer it. I think a number of landlord associations offer it, but I think they do charge for it from my understanding, although I don't know if anyone is a member of another landlord association, but I do know probably the biggest landlord association does offer a mediation service, but from my understanding, they do charge for it. But local councils, absolutely, they would offer a mediation service in the sense that they want to stop someone becoming homeless. It's very costly to a council for someone to become homeless because it's the cost of bed and breakfast is extremely expensive. From my experience, and I worked with a local council down on the south coast where I'm from, back in the early 2000s in relation to housing homeless families, and the cost of putting them into bed and breakfast is almost double the cost of what it would cost them to keep them in private rented. So actually there's a massive incentive for local councils to try and reduce or stop someone being evicted. And we'll talk about it on other slides. The councils sometimes will offer rather large sums of money to clear rent arrears and to keep someone in a rented property, because actually it's cheaper in the long run than housing them in bed and breakfast, which again, as I said, it's about double the cost of putting someone into private rented. So there's an incentive there for the local council. I don't know if Giles, if you know if Charnwood Borough have a mediation service, but lots of councils will have a mediation service of some description. Whether it's called a mediation service, I don't know. I'll answer your question a little bit about universal credit, Richard, if that's okay. Guarantors as well. Again, the guarantors are really important in terms of taking them on, especially around student lets. We don't really go into any great detail about student lets, but as you know, guarantors are another good way of minimizing the risk during the tenancy or before the tenancy. And again, you could potentially get a guarantor involved in relation to renewing a tenancy. I'm not going to renew this tenancy unless I now have a guarantor in place, which you're allowed to do so. I'm not saying that it's going to encourage or it's going to be a real something that you can force a tenant to have, because obviously the tenant is currently in situ. But you could say, look, I'm prepared to offer you a 12-month tenancy, give you some certainty, but I do want a guarantor in place when I'm creating this renewal tenancy. So guarantors are an important part, and I would certainly say at the very start of the tenancy, before I'm doing my application, if there's any concerns about the applicant, whether the job security, whatever it's going to be, then I would certainly say guarantors are a good way of reducing or mitigating your risk. And we don't go into great detail about guarantors today, but for those that have been on my basic law course, there are certain things that you need to consider when you are taking on guarantors to make sure that you mitigate your risk when you're dealing with guarantors. So all the guarantors that I used to take when I was a letting agent were those guarantors that were property owners, because if they don't pay, then as the landlord, you have the ability then to put a charge against their house or their asset. So in most cases, I would make sure that I check that they were a property owner. Ideally, you want them to be in England and Wales, because it's a lot easier to pursue debtors where in England and Wales rather than Scotland, because Scotland has a slightly different judicial system. So guarantors are good. And the other one is guarantor schemes. So there are a number of them out there. I think Housing Hand is one. I think there are a couple of other guarantor schemes out there which a tenant can pay a fee for, which is allowed under the Tenant Fee Act, and they can take out a guarantor that way. So if you did have concerns about a tenant or an applicant, shall I say, you do have the ability to use these outsourcing schemes. So in addition to personal guarantors, such as parents or next of kin, you do also have the ability to utilise these companies that have appeared in the last couple of years who will offer the tenant a guarantor. Again, I've not used them personally myself, so I don't know from an efficiency side and from a professional side how good they are. As always, they're only as good when you've got a problem and you want to be paid out. So it'd be interesting to hear if any of the attendees here have used one of those schemes, or have used or currently use one of those schemes in relation to cost, and also in relation to any claims that you may have made, if at all. I don't know. So guarantor schemes are really important as well. Guarantors and the ability to use company schemes in that relation are really good as well. And again, I know this is something which I'm sure you're all doing, but detailed referencing and credit checks, making sure that you've done the relevant checks for that person. You've gone into great detail. No applicant's going to give you a bad referee as a general rule. If they do, then you probably don't want them as a tenant, but as a general rule, they're not going to give you bad references or bad referees. So, but again, it's your responsibility as a professional landlord to make sure that obviously you double check those references. Again, if they've given you a landlord reference, double check to make sure that that landlord they've given you does actually own that property. Because they've said they're a landlord, it doesn't mean they are. So again, from your perspective as a professional landlord, these are the things that you should be double checking, and hopefully that will reduce any potential risk to you at a later stage. So references, there are lots of professional referencing companies out there that you can utilize if you want to. If you're doing it yourself, which I know lots of you will do as landlords, then again, it's just making sure that you double check those references to make sure that they are bona fide. Other things about getting to know your tenant, which I'm sure lots of you will probably know a lot more about your tenants than the normal letting agent, so to speak. You'll have much more of a personal relationship with your tenants, whereas letting agents tend to be a little bit more standoffish, if that's the right way of referring to it without being disrespectful. So again, it's just about making sure from your position that you get to know your tenants. So maybe you can get a good idea or a better idea about whether someone may be getting into financial trouble. So the earlier you get that alert, the earlier you can intervene. And again, it's incredible, if I'm being honest. When I used to be a letting agent, I remember we had some landlords who used to do let onlys. They would come to me and say, "Well, I've just worked out my tenants 5 months in arrears," and I'm thinking, really? For me, it would be almost checking daily or whatever it's going to be in relation to rent arrears or rents not coming in. So again, I'm sure most of you are going to be professional. I'm sure most of you on this course, because you are very diligent in dealing with rent arrears, or dealing with seeing if there are going to be potential issues with rent arrears. But it's really surprising to see how many landlords don't actually check on a regular basis that rents are coming in, and they don't realise until maybe 3 or 4 weeks after it's due that it hasn't been paid. So again, getting to know your tenant is really important. Their lifestyle, again, what type of industry that they're in, will COVID have a problem upon them? Again, we're talking about industries that they work in later, because one of the things that I had when I was a letting agent was that we had a couple of tenants get into rent arrears, And actually, because of the industry that they had worked in or were currently working in, there were benevolent funds available for them to help them through a particular crisis period. So some of you will probably have come across the Royal British Legion in terms of helping tenants. I had one who was a train driver. He lost his job, his subsequent job, and he was able to claim against the benevolent fund, which actually funded his rent arrears and did other bits and pieces for him. So if you get to know your tenants and you can assist them in times of crisis, which is really where rent arrears occur, then you can help reduce their rent arrears and help them stay in your property. And obviously, it's a win-win for everyone. But you do need to know who your tenant is, what is their life story, so to speak, without going to the harassment scenario. But there are plenty of funds out there if you know how to access them. I fully accept at the moment they're probably being accessed left, right, and centre. But from your perspective, it's just really important to understand who your tenant is, so you can just make sure that you minimise or you manage the risk that you may be in sort of experiencing as a landlord. The last point on this particular slide is about the tenancy itself. So the other issue is that you really want to make sure that the payment date is pretty close to or just shortly after they get paid. So if they move in halfway through the month, but they get paid on the first of the month, then it's probably going to be, for me, something that I would consider when I'm creating the tenancy. So if I create a tenancy and it starts, so if the tenant wants to move in today, which is the 14th, what day is it today? It's the 11th of Feb. So I get paid on the first of each month. I'm employed, I get paid on the first of each month, but I want to move in on the 11th of February. So as a landlord, I would probably make the first payment that he or she is going to make me potentially a month and a half. So the first payment that they would make to me would be from the 11th of February until the end of March. So that would be what, a 6-week payment, and then thereafter they always pay on the first of the month, which is the day that they get paid, whatever it's going to be. So your rent payments always come out shortly after they get paid, because then you've got a better chance of getting paid potentially than if your rent due payment is in the middle of the month, which I know sounds common sense, but lots of landlords don't tend to think like that in terms of how they draw up their tenancy. So again, if you've got someone moving in the middle of the month, you can make your tenancy 6.5 months long. That's one way of doing it, or 5.5 months long if you want to do it that way. And always make the first payment a pro rata payment. So in my example, I would get them to pay from the 11th of February until the end of March, which will be 6 weeks, 6 or 7 weeks, whatever it is. So it's a larger payment upfront initially, but it does cover obviously a longer period. And then the next payment would be the 1st of April, which would coincide with my payment date for my employment. So it's all about trying to think of those little issues. I'm not saying if someone's got no money, then obviously you're not going to get paid, but you're more likely to get paid a day after they get paid than 14 days after they get paid. So it's just really trying to work out what's best for you as a landlord. So you can amend your tenancy in relation to payment frequency, whatever's best for you. And that's what I would do as a landlord. So if they get paid weekly, then draw up a weekly tenancy. There are some issues with serving notice. I fully accept that, in terms of you may have to wait a little bit longer to serve notice. But if you have a weekly paid tenant and he or she gets paid every Friday, then it's probably better to word your tenancy so it's payable weekly and the rent due date is weekly, and then you can get your standing order set up. And again, we talk about what we need to do. Again, get standing orders set up. You don't want people paying you in cash or whatever it's going to be. So standing orders are a lot better for you in relation to efficiency, etc. So those little amendments, which I know don't sound a lot, all those help towards potentially mitigating the risk of someone not paying you. But obviously, if they've got no money, then they can't pay you. But just in terms of administrating your tenancy agreements and payments, that's the way I would do it. So just make sure your tenancy agreement's worded correctly in terms of your frequency and when someone gets paid. So that's always a good idea of doing it that way. Joint tenants, because that comes up quite a lot. So boyfriend and girlfriend, or two friends, they're living in a property at the moment. They are jointly and severally liable for the fixed term. So if one of them has to go, as I'm sure most of you are aware, if that person leaves halfway through during a fixed term, then they are still liable for their rent, the whole rent, or because they don't have a share of the rent, because the rent is jointly and severally liable. So they are obligated to pay the whole of the rent, however they pay it, whether they share it themselves, between themselves, whatever is going to happen. If one of them doesn't pay their share, the other person is jointly and severally liable as well. So during a fixed term, they are jointly and severally liable. So if one of them leaves and says, look, I no longer want to live here, we split up, then very clearly you say to them, you're still liable, irrespective of whether or not that you live there, because the contract is a joint tenancy for a fixed term of X months. So you are obligated to pay rent until such time that the tenancy comes to an end, or you serve notice for that tenancy to come to an end. And that equally applies for guarantors. So if you've taken out guarantors, or the tenant's provided you with guarantors and the rent's not being paid, and the guarantor for one of the parties says, actually, the tenant I think I'm guaranteeing is left. No, guarantors by default are guaranteeing the joint and severally liable tenancy, so they would be obligated to pay as well. The only time potentially they may have a reduction in their liability is where potentially a guarantor is only guaranteeing part or a percentage of the tenancy. So I see some guarantees that say they will only guarantee 25% of the liability, which is fine, that can be done. So they would only be liable for 25% of any rent arrears that are outstanding. That normally applies to student lets as a general rule, but again, guarantors are equally responsible for rent arrears as they accrue. And we talk about guarantors on another slide, but again, really important that you keep your guarantors up to date regarding rent arrears. So as soon as someone's missed a rent payment, you should be contacting the guarantor. It's not harassment, it's all about communicating and updating the landlord accordingly in relation to any liability that they may have as a guarantor. So it's really important as part of your due diligence and your duty of care to the guarantor to make them aware if there is any liability being incurred on their behalf. The other one which causes huge confusion at the moment, and I won't spend too much time on this because you can almost run a whole webinar on its own, but it's where when one joint tenant serves notice during a periodic term. So the fixed term, they are fixed in for whatever fixed term you've agreed. If they want to leave during that fixed term, they're still liable for the rent payments during that fixed term, whether they're living there or not. Now, when it goes periodic, the legal position, and we have court cases on this, is that if one of the joint tenants serves notice, that ends the tenancy for all, or ends their rent liability for that person who wants to leave. So just be wary of that, because that's something obviously shelter, CAB, housing advice, solicitors, the internet will give in relation to advice to a tenant. So just be wary of it, because it's not a simple solution in relation to what you can do as a landlord to reduce or mitigate your risk. But the options available are hopefully both tenants leave, or all the joint tenants leave at the end of one joint tenant's notice. You're happy to keep the remaining joint tenant and you create a brand new tenancy in their sole name. They find someone else to replace the other joint tenant, so you create a brand new tenancy, and that removes, hopefully that mitigates any risk that you've got. The real problem is if the current tenant or one of the joint tenants leaves because their notice expires and the other one stays in situ and stops communicating with you, which is a potential. So what can you do then? And that's the real issue, because ultimately your only real sanction is to start court proceedings against that remaining joint tenant and to remove them from the property. So that can be quite a complicated and costly process. So if you have that problem, I'm sure Giles will hate me saying this, give Giles a ring, because it's one of those situations where it's not straightforward, and you'll probably need a little bit more advice about how you proceed with that. The only thing that I'm going to say on this particular webinar is that if you do take money from a remaining joint tenant, after one of the other joint tenants has served notice during a periodic term, you always receipt the money that you received as means profits, MESN profits. You don't receipt it as rent. You're not wanting to create a brand new tenancy in that sole tenant's name, so therefore you always receive any money that you receive from that other joint tenant as means profits. So that's very quickly for joint tenants, because I know that's going to pop up lots and lots of times. in relation to what you can and what you can't do. Guarantors, as I said earlier, update and advise them accordingly. You can do that. There's no data protection issue there. They are bound by the contractual terms of the guarantee. So I have no issues about contacting the guarantor at all at the earliest opportunity. I don't know how many of you actually take guarantors, but again, from your perspective, it's really important that you make them aware of any change in the tenant circumstances which would increase their liability, whatever it's going to be. The last thing you want is a guarantor wriggling out of their responsibilities. So I would keep them up to date as much as I possibly can throughout the whole of the tenancy. If there is anything that changes which I believe will affect their responsibility or liability as a guarantor, that would be my belt and braces process as a landlord. And I would keep all those notes and make sure I have a very detailed log of what I have said to the landlord or said to the guarantor about changes in the tenant's particular circumstances or any potential change in their risk as a guarantor. As I said earlier, I always take guarantors. I would probably take guarantors as a general rule now. Why? Because guarantors, so long as they're property owners, I've probably chased 5 guarantors through court in my lifetime, and each and every time we've got payment. Why? Because we always have the ability to say, if you don't pay, we will get a charge against your property, and that's what we threaten, so to speak, and it is quite a good bit of leverage, because obviously if they come to remortgage the property, the mortgage company will see that there is a charge on the house, so they're less likely to offer a mortgage, or they may offer a mortgage but at a higher rate. And in addition to that, you also get interest on your debts. So obviously the longer they don't pay, the more interest that will pile up. So it's always a good way of doing it. So just because they say they're the bank of mum and dad, it doesn't mean that they're going to be bona fide as a guarantor. So I personally would always make sure that they are property owners, and you can check that on land registry, just to make sure that you are taking on those persons that you have the best ability to chase through court if the situation ever arises. So during the tenancy, again, these are things that I'm sure you'll be more than aware of, but these are things that we just need to reiterate. It's one of those situations where, and I know we're going to be talking about the debt respite scheme, get that word right, shortly, but there is no harassment in dealing with rent arrears or the potential delay of payment of rent in a very strict way. And I think we're all pretty agreement in that, is that you've got to contact them immediately. So if they haven't paid their rent, and you know they get paid in terms of their wages on the last day of each calendar month, they haven't paid you, then on the first, you should be contacting them in some shape or form, whether it's a friendly email, whether it's a phone call, whatever it's going to be. It's one of those situations, if I'm sure you're all aware of this, I'm probably saying something which I'm sure you're all going to be doing anyway, but just to reiterate it in terms of contacting someone at the earliest opportunity in relation to what can I do as a landlord to help you maybe deal with this particular issue, because in most cases it may be a temporary issue. If it's a long-term issue, then there's not going to be a great deal as a landlord you can do. But in temporary scenarios, which lots of people will be suffering from temporary cash flow issues, what can I do as a landlord to help you mitigate that potential risk? So contacting them immediately, asking them if they need any assistance from you as a landlord. And there's some of the issues that we'll talk about on the next few slides, which may sort of demonstrate what you could do as a landlord. Obviously, there's no reason why you can't serve notice as early as you possibly can. You can serve a Section 21, you can serve a Section 8 if the grounds are applicable. So you don't have to enforce those notices. You may decide, actually, if I serve notice, that may put me on the back foot with the tenant. So you've got to take that judgment, obviously, in terms of your own personal circumstances. But there's no reason why you can't serve notice. And some landlords put off serving notice when it's very clear that actually this situation will not get any better. So there's no reason why you can't serve notice early, and I would encourage you to serve it early if the circumstances dictate. I would not hold off. My experiences are that if something's going to go wrong and you have that gut feeling it's going to go wrong, then I would get notice served as the earliest possible stage. Just need to be mindful, and again, there's a bit of ambiguity about this. As you know, at the moment, the notice periods for Section 21 and Section 8, unless the arrears are more than 6 months or more, are for 6 months. So if I've got a tenant in rent arrears of 3 months, if I'm serving notice under Section 8, I need to give 6 months notice. Those extended notice periods, it runs out at the end of March. So the March the 31st, it goes up to. So the government could extend it again. So that 6 month notice period goes on for another maybe 3 to 6 months. We don't know. So at the moment, if you serve notice today, it would be 6 months. But potentially, if you serve notice in April, we could go back to the old notice periods, which are a lot shorter. But at the moment, we don't know. I've got the impression myself that the notice periods will be extended, as in the 6 months that applies today for a Section 8 and Section 21 will still apply in April or May, but we don't have that at the moment. So you'll need to take that factor into account when you're dealing with serving notice. But that's something which I can't answer today, obviously, because we don't know. We have to wait and see what happens in the next 4 to 6 weeks. I assume a lot of it will depend on the rollout of the vaccine and what happens with the route map, which the PM will come out with on the 22nd of February. The other one is reducing rent where applicable. And again, I think this is more a psychological scenario. So if someone can't pay the rent because they're £150 short each month, then it may be, from your perspective, a better reason to reduce the rent by £150 for a period of time. Because sometimes if you say, look, I want you to pay £850 and they can only afford 700, they might not actually just even pay you the 700. They think, well, I can't pay them £850 or them £850. I'm just not going to pay anything at all. So again, it's psychologically wise, and again, I'm not overly experienced in that scenario, but I would certainly say if a tenant comes to you and you've worked out their budgeting or their income and expenditure, then I would personally say that I would be inclined to reduce the rent for a temporary period of time, if that's a better way of managing that debt. So long as they pay you the 700, I'd rather get 700. I'd rather get 100% of 700 than 0% of 850. So if doing that makes them pay the 700 because they don't feel they're getting into debt, then that's a better way of doing it than rather than you still trying to charge them 850 and them not paying you a penny at all, which can be in the psyche of some tenants. So that's what I would encourage you to do, and I'm sure lots of you have done that in terms of the COVID issue. I know lots of my clients, a lot of them reduce the rent for a period of time, and that can be as simple as an addendum. So one side of A4, name of landlord, name of tenant, name of property, and whatever you've agreed in terms of the rent for a period of time. That would be sufficient in relation to confirming what that agreement is. So you don't have to draw up a brand new tenancy, so you don't have to worry about all that malarkey and all those shenanigans. A simple addendum confirming what you're doing for a period of time in terms of a lower rent would be sufficient. And then after that period, it would go back to the normal rent that you would be paying. So I would encourage you to do that if you've worked with a tenant and you've budgeted their income and expenditure and they can only afford X for a period of time, whether it's even universal credit. Universal credit are only going to pay X until this person gets back into their own profession. That might be something that you need to consider when you are dealing with tenants, which I'm sure some of you have done already. Just in terms of your universal credit, because obviously there are a number of people now that will be on universal credit, a number of your tenants. So you can assist in the application if you want. It is quite complicated because obviously there's a lot of personal stuff on there. But in terms of what you can do in relation to getting direct payment, so you can ask for direct payments if they are in arrears. I think they still talk about the 2 months in arrears, then you can ask for direct payments. However, I know lots of people, lots of landlords and agents who already dealt with it in the sense that as soon as the tenant falls into arrears, they've contacted Universal Credit and asked for the direct payments of the housing element of Universal Credit direct to the landlord or the agent. And again, I would encourage you to do that. I fully accept that there's the potential clawback, which this still applies, but from my perspective, that's what I would be doing as a landlord. So if someone was on Universal Credit and they were in arrears of any amount, then I would potentially be going to the job centre. So if you've got their national insurance number, you don't always need their national insurance number, but it helps. A copy of the tenancy agreement, a copy of the rent statement, and then take it to the job centre. The only thing at the moment is I can't remember if the job centres are open. I think they are off the top of my head. I'm sure someone will tell me if they're not. But I would take it to the job centre because they are the organisation, the DWP now deal with universal credit. So they're the persons, not the local council, it's the job centre. They are the ones that will be dealing with universal credit. So that's one good way. And I've had a couple of clients in my local area who've done that recently. And they got payments actually really quickly in terms of direct payments from DWP. So it was actually quite a straightforward process. I don't know if anyone's done that recently, but if you've got a tenant who is claiming universal credit now and is in arrears, then I would do that as soon as they do fall into arrears. Chelsea, I assume you're an agent, so that could be you, yeah. So long as you've got obviously so your details, because obviously your details will be on hopefully will be on the tenancy agreement as well. But yeah, so payment to you as the agent, you can do that. So both of my clients were agents, so they both did it. No, you don't need the tenant's consent. So the law allows you to seek direct payments if the tenant is in arrears. I think the default position is 2 months, but the DWP always say contact us as soon as possible if someone's fallen into arrears. So I would do it as soon as you think they are, as soon as they fall into arrears, then that's when I would do it. Obviously, the DWP can say, look, we're not going to pay you until they're 2 months in arrears, but I personally would get the ball rolling as soon as possible. I'm not too sure about over the phone and email. I mean, because I'm sure you can do it. It's just both my clients in my local area both went to the job centre because I said that was the quickest way of doing it, because you actually physically see someone and someone will process it there and then for you. I don't know if anyone has any practical experience of that, but I'd be interested to hear if they've done. But I know it's happened because it's happened in the last couple of months for someone. Other ones are, this is the council help. So again, each council is slightly different. I fully appreciate Nottingham City Council or Charnborough Borough Council or I'm trying Gedling Council or Derby City Council. Whoever it's going to be will have a different raft of grants available. So DHP, which is discretionary housing payment, comes from the local council. So again, they have a large fund available, and it's been increased recently because of COVID. So that can be used in any which way the council see fit in relation to keeping people in accommodation or anything to do with someone's housing needs. So again, there could be large sums of money available there potentially if your tenant's fallen into arrears and it's for a period of time, and paying the arrears off could keep them in occupation of that property. The local council would consider it, and that applies also to the housing fix it fund, as I call it. So my local council had a housing team, and I think they had a certain amount of money each year, which again, very similar to DHP, which is the discretionary housing payment, kept someone in the home if that person fell into rent arrears. So those are the things which the tenant needs to approach the council with. So again, understanding someone's circumstances, encouraging the tenant to go to the local council, helping them get to the local council if that needs be, is a great way of potentially of reducing arrears. So if they say, look, if you've got £2,000 worth of rent arrears for a temporary period, and you approach Nottingham City Council and say, look, this tenant, I might serve notice on this tenant, or this tenant said, look, my landlord might serve notice on me because of my rent arrears, but if you pay the 2,000, they're happy to grant me another 12-month tenancy because my circumstances are now in such a position that I can afford to pay the rent moving forward, then they would consider it. Absolutely. And I think Giles has just texted to say, or messaged to say that Nottingham City Council do that. So all those avenues are open to a tenant. I know it's difficult when a tenant's in a certain situation, they may not feel or have the motivation to do it. But from that perspective, they would certainly consider it. Because again, for those that were here earlier, I said the cost of council housing these tenants is a lot more than paying the arrears off which they potentially have incurred. Yeah, it applies to HMOs as well, roomlets, I would assume, although as a general rule, they are less. There's less responsibility to the local council for single people, just to make you aware of that. Yeah, so Rebecca just says Derby City Council, absolutely. So I would get your tenant to be approaching the local council in relation to any funds available there. I'm not saying there's huge amounts available. There are amounts available, and I think they would obviously do it on an individual basis as to where they would help. But as a general, it's mainly families, but I fully accept they may also cover HMO tenants as well. Yeah, HMOs, I don't know if you, Abby, whether yours were single tenants. I assume there were HMO tenants, but there's certainly those funds about. And then individually for the tenants, they could apply for budgeting loans or emergency assistance grants as well themselves. So you don't have any involvement in that at all. They can apply themselves for that in relation to their day-to-day living, which again, if it helps them with their day-to-day living, it gives them the better opportunity to obviously pay the rent to you. So it's all about looking at the bigger picture, if that's the right way of saying it. And then my last slide on this particular one, you'll be glad to hear, is other factors. So again, it's just something, again, you'll need to be aware of. Industry grants, as I said, I dealt with the Royal British Legion a number of times because a number of my tenants were ex-forces, and they were really good, really good. They provided tenancy support services. They actually furnished a complete flat for one of my tenants or one of my applicants. They cleared his arrears off when he had an issue with benefits. So they are really good. I mean, I fully appreciate, they're a fantastic service. So the Royal British Legion, for those tenants, have a history in the armed forces. It can even be a family member. So I had one tenant where he was the son of a ex-forces member, and he got help because his dad was in the forces. So it is quite a broad assistance package. But again, if tenants they're in that scenario, then get them to approach the Royal British Legion or those industry grants. I said the other one I had was a train driver. I didn't even realise there was a benevolent fund for train drivers. I think there is a benevolent fund for letting agents and estate agents somewhere. So if we ever fall into trouble, then we can claim against that fund. So it's just really important that we look at those things and have all those options in place in relation to reducing arrears. The other one is offering early termination. Again, I would always say if a tenant can't afford to live there, then you're better off cutting your losses and ending the tenancy early. I would try and put as least hurdles in the way, which I'm sure most of you will be aware of. There's no point trying to keep someone there if they don't want to be there or they can't afford to be there. So if you can get them to agree early surrender or ending the tenancy at the earliest possible stage, then I would certainly consider doing that. And the other one, as I said to you before, serving notices is really important. We won't go into all the compliance documents around it, otherwise we'll be here all day. But as you know, serving notice is probably the easy part. It's all the compliance surrounding it, which I get lots of questions about, and which I'm sure Giles gets lots of questions about, because lots of landlords and some agents aren't getting them right. So deposit protection, how to rent guides, EPCs, gas safety records, all the things that you should be doing in relation to compliance, you need to make sure that you are doing correctly in that scenario. So that's the minimizing rent arrears section done. I'm just going to quickly go through the debt respite, I pronounce that word correctly. So this starts on the 4th of May 2021. As I said to you before, I don't personally think this is going to be a massive issue for landlords. It sounded when it first came out, it didn't sound great, but when you go into greater detail, I can't really see it being used apart from those persons that have temporary issues, or those persons obviously that have greater mental health issues. But you can still serve a Section 21. So in a sense, you can still get your property back in the same way that you could get it back prior to this coming into force. So it just gives a bit of breathing space, as it's called, for certain people in certain circumstances. So I don't see it being a big issue as probably when it was first announced, when it sounded pretty awkward for landlords. But ultimately, I think it will be a relatively light touch piece of legislation, which will hopefully help those people that are suffering from temporary issues, which they need some breathing space. So a certain person, the tenant in our scenario can contact a debt advisor or the local authority and say, I'm in this particular scenario, can I get respite from debtors, i.e. you as a landlord? And then obviously they can go through a number of processes in the application. So the debt advisor or the local council need to make sure that this is actually appropriate for them. And in some senses, from our perspective, that's going to hopefully filter out those landlords or those tenants, should I say, who are trying on. So in most cases, I think the breathing space will be very simple in terms of, or very effective for certain types of tenants. So in terms of your notification, you get it electronically or by postal notification. Hopefully you'll get it electronically in most cases. So that starts the same day. So the breathing space for that tenant starts the same day as you receive that electronic notification from the debt advisor. If it's sent by post, it starts 4 days after the letter has been sent. So the date of the letter. So electronically, it starts immediately. If it's sent by post from the debt advisor, then it starts 4 days after it's been sent. So from your perspective as a landlord, you have to stop all actions in relation to chasing that debt. So whether it's a Section 8 notice, whether it's a possession order in relation to that debt, so you can still enforce a Section 21 notice, but you can't enforce a Section 8 notice, which is in relation to a rent arrears. So it's only going to stop certain possession orders in relation to those debts. You must apply protections, i.e. you basically must stop contacting the tenant regarding that debt. You can still contact them about current rent, etc., and repairs or whatever it's going to be, although be mindful of their mental state potentially. But as I said, in terms of the legislation, it's all about the debt, not ongoing liability or other things that you may be doing as a landlord in relation to your gas safety records, EICRs, I know are an issue at the moment, inspections, although I wouldn't be doing inspections, etc. No, not in terms of that debt, I would say. I need to pretty double check on that one, Giles, because in theory the guarantor is not under the debt scheme. So I just need to double check on that one. That's a good question. But in relation to any questions you've got regarding that debt, you have to contact the debt advisor, and all their details will be on the notification that you receive about the breathing space commencing. So you would channel all those questions to the debt advisor. That's probably the best way of dealing with it. So I need to double check on the guarantors, but if the guarantor is not subject to the breathing space moratorium, then I'm going to assume you can contact them, but I'm just going to double check that, Giles. That's a good question, which I'm not aware of I can answer at the moment. But as I said, the protections are in place, and I mentioned them earlier. So you can't charge interest on the debt that they owed, or you've got to stop charging interest. You can't do any enforcement, whether it's a possession order or if you had a money order against them, whatever it's going to be. Yeah, you can. I'm not saying you'd want to, Giles. As I always say, this is brand new legislation. You can challenge a breathing space order through the court, etc. But how long is that going to take you? It's going to take you probably a lot longer than 60 days would be my guess. So good luck on that one. But if you want to try and challenge it for me, I'll let everyone know how you get on, Giles, if that's okay. Can't serve a Section 8 for grounds 8, 10, and 11, which are our rent arrears grounds. You can charge them. You can serve them for other breaches. So antisocial behaviour, breach of Immigration Act. So long as it's got nothing to do with rent arrears, then you can serve a Section 8 notice if you wanted to do so. I'll get on quickly with the rest of the slides and we'll go to the questions. I know we've only got a few more minutes left. You can't enforce a possession order. So if you've got a court order, you've basically got to sit on it until such a time that the breathing space comes to an end. As you probably know, there are two options in terms of breathing space. So we have the standard breathing space, which anyone can apply for. It lasts for a maximum of 60 days. And there is a midway review, which you can have your your communications with. So they've got to have the legislation requires a legal review halfway through the standard breathing space. And the important thing to remember from our perspective is that they're only going to get a standard breathing space if the debt advisor feels that they can still continue with their ongoing liabilities. They may not be able to deal with the debt, but they might be able to pay you rent moving forward still. So if that's the case, then there's a very good likelihood that the debt advisor would say that the standing breathing space is a good option for this particular tenant. Now, if they couldn't afford the rent full stop, and they weren't paying the rent, and they had no intention or no ability to pay the rent moving forward, then from my understanding of how this will work, the debt advisor would not suggest or allow that tenant to go onto the standard breathing space register. So they're hopefully going to filter out the people that can and the people that can't. Although I fully accept that obviously we're not going to really know until it works in practice. But that is the intention of how it's meant to work. So again, it's not suitable for those that just need some budgeting help. They're just a bit rubbish with their money, a bit like myself. Those with assets which they can be sold to pay off the debt. Those with other debt solutions. So can they go bankrupt? Is that a better way of doing it? Can they get a debt management plan? Whatever it's going to be. So it's only really going to be for those that are, as I said, in temporary scenarios where they've lost their job, they're applying for universal credit, and there's going to be a lag between universal credit being applied for and potentially it being paid, as a very simplistic example. I'm sure there are others, or they're unemployed for a period of time, but they've got a new job starting in a month, whatever it's going to be. So I think that's the type of person that the breathing space moratorium is trying to target, would be my understanding, but I fully accept it could be slightly different to that. You never know how it works in reality. Be interesting to see. And you can't apply for it if you've used it in the last 12 months. So as you'll see with the mental health breathing space, it can be applied for continuously, or they could stop it and then a week later they can start it again. But in this particular scenario, in terms of the standard breathing space, it only applies, you can't apply again if you've used it in the last 12 months. So it's not meant to be a permanent fix, if that's the right way of referring to it as. And then the mental health one, which again, hopefully, as I said, from our perspective, it's not going to be something that we see that often. But again, they need to have the mental health professional, and there's a whole list of who they define as a mental health professional, can apply to the debt advisor to say, by the way, this person's undergoing treatment, and they are suitable for this particular breathing space. But all the same eligibility criteria apply to the mental health breathing space. So can that person still afford to pay their ongoing obligations? Because if they can't, then they won't probably get the mental health breathing space. So the same eligibility criteria apply. The only thing that doesn't apply is the 12-month bar, in the sense that they could have a mental health breathing space, come off the mental health breathing space, and then reapply it a week later. So there isn't that restriction on that person. They can apply as many times as they want, so long as the mental health professional and the debt advisor believe that person would benefit from the breathing space for the mental health requirements. And again, this is ongoing. So unlike the standard breathing space, which is a maximum of 60 days, this one is for so long as they're under mental health treatment plus 30 days. So this is a little bit more open-ended. Again, I'm not too sure. I assume there is a process and a procedure and a timeline how they deal with mental health assessments. So again, someone else might have better experience than me. But say, for example, it was 6 months. It would be 6 months, and then 30 days would be the period for which that mental health breathing space process would apply to that particular tenant. So that was very quick. Apologies, but that's bang on 11:59, which is pretty good timing. So as I said, I don't believe it's going to be for anyone that has permanent issues with managing their finances. This is more to do with a temporary measure to deal with those issues which have been ascertained or incurred prior to a breathing space being allowed. So if someone can't afford to pay the rent moving forward, whether they're on a standard or a mental health breathing space, then they would probably not be allowed to be under those protections, as I call it, because in the end, they're going to be evicted eventually, or they're going to be evicted because they can't afford it. So there's no point trying to delay the inevitable. So for me, it's only going to apply to those people where it is a temporary issue. And as I said, you can still serve a Section 21. You still have that right, so it doesn't affect that right at all. I mean, obviously, the only issue at the moment is the length of your Section 21 notice, which sadly is 6 months. So you'll be glad to hear, Giles, that's bang on 12 o'clock. I said it wouldn't be an hour, but it almost was, or is, shall I say. I know there are a few questions floating about there, and I'm sure you answered some of them, Giles. So is there any comments?
I think there's one question, Daryl. There's the final bit of text in the chat box. Have we answered that? About a joint and several tenancy agreement with one tenant?
Yeah, I need to double check on that, but I think I did read that. If it's a joint debt, then it's the whole debt that applies. So if you can't chase that debt because in a sense that person is liable for that debt. So yeah, sadly I think that is correct. But I will double check on that. Is it Tracy? I know you put your name on there. It is Tracy. Yeah, I will double check that, but I think that is I'm 99% sure that is correct.
That's quite scary.
Yeah, but as I said, I don't think this is a permanent scenario. I don't personally think there'll be that many people that would be eligible for it personally. I'll be interested in how it works. I have no idea how it's going to work. I mean, a debt advisor might just say, okay, you're fine, you can go on it, but we're not going to know. But the legislation has put out the criteria, and from reading the criteria, and don't forget you can challenge it. I believe that it's limiting the number of people that can apply for it. Would be my educated guess. But I have been wrong before, as you know, Giles. So I'm not going to put my neck on a chopping block on that one. But that's how I think it will work.
Well, clearly, as it's a very fluid piece of legislation. I know it doesn't come into effect until the 4th of May, but we'll keep members updated as the changes occur. Are there any other questions for Daryl at this time? I know that we are slightly over time on this webinar. Okay, doesn't appear to be. So if I could just say before we close, and obviously Daryl might just have something to say as well, I'd like to thank Daryl on behalf of EMPO for presenting this morning. And we actually have 3 landlord forums coming up. The first one is on the 30th of March, the Lincoln Landlord Forum. All of these are going to be online. We're doing them all in association with the respective councils. So the 30th of March is Lincoln, the 1st of April is Derby, and the 29th of April is Northampton. And I'm very happy to announce that Daryl will be presenting at all 3 of those webinars with other presenters, and Daryl will be focusing on how to set up a compliance tenancy, which again is a big sort of issue that comes up regularly on the EMPO helpline. So from where I'm sitting right now, I'd just like to thank Daryl for his time this morning, and that's as much as I've got to say. Over to you, Daryl, finally.
No, thank you, Giles. As always, it's been a pleasure. Yeah, as I said earlier, serving notices is the easy part. It's getting the compliance correct, which is the difficult part. So, yeah, that's always the issue that I've got. I've got a couple of questions this morning where solicitors are questioning people's compliance. So that is so important. So yeah, absolutely. And have a great day, guys, and keep warm. And hopefully we'll see you again very shortly. Okay, goodbye.
Thank you.
This conference will now be recorded.
Not recorded.